Ready to roll? All right, everyone. My name is Danny Garone. I'm with the Arizona Ombudsman's office located in Phoenix. I'm here to talk to you a little bit about open meeting law today. I realize it's not the most exciting topic in the world, but it's a very important topic that a lot of people do feel very strongly about. So just a quick aside about the office I work for. We're a small legislative office. We're part of the legislature. We're located in Phoenix. Our primary mission is to take and investigate complaints against Arizona state agencies. When it comes to public records law and open meeting law, our authority to investigate extends down to the local level, counties, municipalities, special taxing districts. Part of that authority when it comes to open meeting law and public records law is to educate and produce educational materials for the public and public officials. So that's why I'm here today. So who can enforce open meeting law in the state of Arizona? It's pretty limited. Essentially, it really comes down to the Attorney General's office, the county attorneys, and the courts. Those are the only three entities that can actually enforce the open meeting law. And the way the Attorney General and the county attorneys usually do it is they will investigate a complaint, and if they find a violation, they'll try to work usually semi-formally to get to some sort of resolution with the public body instead of taking you to court and trying to seek penalties. So usually things are resolved with sort of settlement agreements or something along those lines where you get some training, don't do it again, and the situation is resolved. Additionally, besides the Attorney General or the County Attorney's Office, someone who thinks there's an open meeting law violation can just take you straight to court. So if someone thinks that this board doesn't follow the rules, they can sue, take you to court, and let a judge decide what to do about it. Our office, we can investigate, but we don't have enforcement authority. We can find violations and publish reports and send them over to the legislature, to the counties, to whomever, but we can't actually levy penalties or issue orders. So what is the open meeting law? It sounds relatively straightforward. It's a body of law that makes meetings have to be open to the public. Essentially, the point is to maximize public accountability and transparency so that the people, the ultimate bosses when it comes to government, get to see how their elected officials are doing their jobs, how decisions are being made, how money is being spent, basically just so you can see the gears of how government is turning. Who must comply with the open meeting law? This is pretty straightforward in most cases. It's public bodies. So essentially, any multi-member governing body of either the state or the county or local government. So any government multi-member body that can make official government decisions of one type or another are probably going to have to follow open meeting law. There are some interesting cases or interesting situations. The definition for public bodies in the open meeting law includes corporations or other instrumentalities, basically of a state or subdivision. So theoretically, there are some in-between type bodies that will have to follow open meeting law. But for the most part, if you're government, if you're elected, if you're appointed to a multi-member board, you're going to have to follow open meeting law. There's an Attorney General opinion on how to handle some of those tougher cases where you're not sure whether the open meeting law will apply. This is a test, 7 factors to consider when determining whether it's a public body that needs to follow open meeting law. The courts haven't enshrined this in law, but this is a pretty good indicator of how a court would probably decide it if it was ever challenged. But if you're ever not sure about whether your body should be following open meeting law, this is a good place to start. Not only do public bodies have to follow open meeting law, but also committees for public bodies have to follow open meeting law. So if you have standing committees, special committees, any sort of advisory or subcommittee that's appointed by the public body, probably going to have to follow open meeting law whenever that committee meets. That includes advisory committees and subcommittees, and those are defined specifically in the open meeting law, as you can see on the screen. Basically, anything that's created, any committee that's created on motion by the public body or created by the presiding officer of the public body. So if your chair unilaterally creates a committee, that committee is going to have to follow open meeting law. Even if the committee doesn't really have any authority beyond making recommendations. The way the statutes are structured, it does seem like there might be some types of committees that wouldn't have to follow open meeting law, but it's not 100% clear. So when in doubt, if you have a committee or some sort of smaller version of your public body, whenever they meet, have them follow open meeting law. That's the easiest way to do it. It'll be a hassle sometimes to follow the open meeting law, but then you won't get sued, the Attorney General won't come knocking, and it's just a more transparent, open approach that takes any doubt out of the equation. One of the most common questions that comes into our office is, I just got put on a board, or I just got elected, and I heard something about open meeting law. What sort of training do I need to get before I start rolling on this? Well, the statutes, the open meeting law statutes, don't really have a lot of requirements. Basically, at least a day before you take office, you're supposed to review open meeting law materials either provided by the Secretary of State or the county, depending on what level of government you're at. So if you get elected to the Board of Supervisors, the county should have some open meeting law materials for you to review. And that's all you need to do. That's all the open meeting law says. Your county or your board or whatever public body you're part of might have additional requirements. And I believe there's also some additional training requirements in the special taxing district statutes. But as far as the open meeting law goes, this is all you need to do. So what is the open meeting law? What do you have to do? What is a public body required to do in order to follow the open meeting law? This slide really lays out the most important things you got to do. If you can remember anything from today, remember these 6 items and you're going to be in a very good position. So you have to, whenever you meet, you're going to have to provide notice, have an agenda, you're going to have to meet in public and let the public attend. You're going to have to take all legal action in public, in front of everybody, and you need to prepare either minutes or a recording for your meeting. Those are the 6 big points. So before we jump into each one of those 6, what does it mean to be having a meeting? When does open meeting law apply? Well, open meeting law applies to any meeting as defined in the open meeting law statutes, as defined in Title 38. And the way a meeting is defined is any gathering in person or through any technological means of a quorum of a public body to do any of those 4 things. So if you have a quorum meeting and they're discussing, proposing, deliberating, or taking legal action, then they're having a meeting. That means they have to follow open meeting law. If you're not meeting this definition, then you have a very good argument that you don't have to be following the open meeting law. So if you don't have a quorum, or you're not discussing, proposing, deliberating, or taking legal action, then you probably aren't subject to open meeting law. The definition of meeting probably is what you use to find a lot of the answers to to open meeting law questions. A lot of it boils down to, this is what's going to happen. Do we have to follow the open meeting law? Good place to start if you ever have that question is to look at the definition of meeting. If what you're doing seems to follow or fit the definition of meeting, then you should follow the open meeting law. If you're not sure, well, better safe than sorry, follow the open meeting law. When in doubt, you should always follow the open meeting law. It's the safer course of action. And as I'll get into in a little while, there's actually a statute in the open meeting law that basically says anyone who has to interpret this, interpret it in favor of openness. So basically, the legislature has commanded, when in doubt, act in favor of openness. So as I just said, the open meeting law defines meeting as a quorum. Well, what is a quorum? As most people know, it's usually just a simple majority of your public body. So if you have 9 members, it's going to be 5. If you have 7, it's going to be 4, so on and so forth. Unless somewhere else in statute you have a different quorum number designated. This is the default in the state. The view the Attorney General's office takes is that if you have vacant seats, you still need to count those in order to determine a quorum. So if you have 7 seats on your board, but you only have 6 members, you're going to use that number 7, that 7 available seats, in order to determine what a quorum is for your board. So if you're missing a few members, it's going to be awfully hard to get a quorum. So you might want to speed it up a little bit in filling those seats to make life a little bit easier when it comes to meeting. Telephone conferencing, pretty common question. Can we meet remotely and still be following the open meeting law? The answer is yes. The open meeting law, the way the statutes are written, the legislature seems to have taken into account and allowed for public bodies to meet remotely, either through telephone, internet, whatever is available, as long as you meet all the other requirements of the open meeting law. So if you're going to have a telephone conference meeting, or some members conferencing in remotely, as I believe was just happening before we got started, I suggest putting that in the agenda, putting that in the minutes to maximize transparency so the public will know who was actually there, who was attending remotely. So the first requirement for the open meeting law, the first item on that 6-item slide, is what's colloquially known as the disclosure statement. You have to have something on your website for your public body that says where people will be able to find meeting notices in the future. So you will have a statement on your website and hopefully filed in a physical location somewhere. So if anyone ever wants to know where they'll be able to find out about meetings, they'll be able to figure it out. It needs to tell the public where all the electronic locations and physical locations will be in which you will post meeting notices. And with just a few exceptions, you need to have it on your website. Special taxing districts can, instead of having it online, they can have it at the county clerk's office. Cities and towns can have it on the Association of Cities and Towns website. But because web posting has gotten so easy, I really, really suggest putting it online. The public pretty much expects it, and it'll alleviate headaches and complaints if you just have it on your website. Just a sample of what that can look like. You don't have to follow this, but you need to have some sort of statement telling people where to find the meeting notices. So you have to have your initial disclosure statement that tells everyone where to find meeting notices, and then every time you want to meet, you have to have a notice for that particular meeting. So you need to give the public 24 hours notice in advance of any public meeting that you want to hold. And it needs to be available to anyone in the public, it needs to be available to all members of the public body, and it needs to be 24 hours in advance. The 24-hour advance notice period can include Saturdays if all the places you're going to post the notice are open and available. So if you have your notices posted online and in the post office, if the post office is open on Saturdays so that people can go see the notice, then Saturday can count in the 24-hour period. There are two exceptions to the 24-hour notice requirement. One is recesses, and the second is actual emergencies. And I'll get into a little bit more detail on those shortly. So what does a meeting notice have to have? Pretty straightforward stuff. You need to be able to you have to put enough information on there that the public will know where and when and what's going on. It needs to tell the public which public body is meeting. Who is it that's meeting? It's the County Board of Supervisors, or it's a particular fire district. It needs to have the date, time, and place. The more specific on the place, the better. If you're having your meeting in a building that has 100 rooms, you should specify which room so that someone doesn't have to wander the halls guessing. And the notice needs to either include an agenda or it needs to tell the public how they can acquire an agenda. I think common practice is to have the notice and agenda be one document. So it'll start with the who, what, when, where, and then it'll have what the body is going to talk about. But instead of doing that, you can just have your notice that says the who, what, when, and where with a line that says something along the lines of, to obtain an agenda, email this person or come down to the county courthouse, whatever. I suggest doing it all in one. It's easier. The public seems to like that better. And then you don't have anyone complaining about how difficult it is to find an agenda. So where do you have to post the notice? How many places, so on and so forth? You have to post the notice in every place you said you would in your disclosure statement. So your initial disclosure statement says, hypothetically, we'll post our notices on this website and at the courthouse and at the post office. Well, then whenever you want to have a meeting, you need to post it at all of those locations. If you don't, you're probably violating the open meeting law. You need to post it on your website with an exception for special districts. They don't have the website requirement. And you're supposed to give any additional notice that is reasonable and practicable. What does that mean? I don't know. The open meeting law doesn't define it. So just use common sense in making it available, and have it on your website and all the places you say in your disclosure statement, and you'll probably be good. Just a couple pointers on posting notices. Some of these are going to seem pretty common sense, but you'd be surprised how often this doesn't work. Make sure it can't be removed. If you have it on up at the post office, make sure someone can't just rip it down. You have a question? Sorry. So make sure it can't be removed, that someone can't just rip it down and hide that there's a meeting happening. If there's text on the back of it, make sure people can read the back of it. It's not required by the open meeting law, but I highly suggest it as a way to protect yourself as a public body, is to regularly post them, and have the same person post at more or less the same time, build up a habit of how you do it, and have that person put a date and time and their initials for when they actually post it. So if someone tries to claim later, hey, the notice wasn't posted where it was supposed to be, or it wasn't posted on time, you have some sort of evidence to show that yes, it was. You have the initial and the date and time. So it might not be 100% dispositive, airtight evidence, but it's a good start. So one of the two exceptions to the 24-hour notice requirement is when you want to recess a meeting, like I believe we're doing right now. You can recess a meeting and then resume it at a later time without another notice and another 24-hour period, as long as you're open to the public about what's happening. So if whoever's running the meeting stands up at the front and says, we're going to recess for 2 hours and then the meeting will start back up, that's great. You don't need to post a new notice. You don't need 24 hours. You just need to make the public aware of when the meeting is going to restart. If you have an actual emergency, you can get around the 24-hour requirement. So in cases of actual emergency, you can hold your meeting in as much time as is possible under the emergency. What constitutes an actual emergency? Well, the statutes don't really define it, but the way it's usually referred to in law is it needs to be a big deal. There needs to really be a serious threat to life, limb, or property that you need to address immediately, or terrible things will happen if you have to wait 24 hours. An example I always like to bring up is I had a call about a fire district that was having an emergency meeting, and the emergency was they had a really hot limited time deal on acquiring a fire truck. If they didn't meet immediately, that deal might not be there and they wouldn't get this sweet deal. That's probably not going to cut it. I have a hard time believing a court is going to treat that as an actual emergency. So you should very, very, very rarely have an actual emergency in which you need to meet in less than 24 hours. If there's a nuclear bomb going off 10 miles down the road, or there's a 10-foot flood coming into the county, that's the type of thing that would be an emergency. So use it very sparingly. So if you have an emergency and you need to have an emergency meeting, what do you need to do? You need to do everything else. You need to provide notice as soon as you can. You're not going to do it in 24 hours because it's an emergency, but you need to give notice as soon as you possibly can. You need to announce in public why you're having the emergency meeting. What is the emergency? Include those reasons in the minutes or in the recording of your meeting, and then post a notice after the fact as if you were posting it beforehand, explaining to the public that we had an emergency meeting, here's what we talked about, here's what the emergency was, so on and so forth. So if people who weren't able to hear about it in time, that way they're able to hear about it at some point, know that a meeting did occur. Probably top 3 or 4 most commonly asked question to our office. What happens if a quorum of our board is going to show up at the same place at the same time for some sort of social function? There's a ball that someone's putting on and we're all going to be there. Our kids are all on the same t-ball team, so we're all going to be down at the field at the same time. Someone's having a party, so on and so forth. Do we have to have a notice? Does the public have to be there? What are the requirements? If you remember back to the definition of meeting, it's a quorum that's going to deliberate, discuss, propose, or take legal action. So if you're just going to have a social event and you're not going to be talking about official board business or anything that can reasonably and foreseeably come before the board for action, then you're not having a meeting. So if a quorum shows up at a t-ball game and all they do is talk about how great their kids are and the weather and how hot it is, you're not technically having a meeting. You don't need to have a notice. You don't need to have an agenda, so on and so forth. But sometimes that can look suspicious. If the public sees a whole quorum of the board showing up randomly at places unannounced and talking, it's going to look like you're having a secret meeting. So what we suggest doing, it's not required, but what we suggest doing is issuing a courtesy notice. A notice that looks just like you would be issuing for a regular meeting, but instead it's going to say something along the lines of a quorum of the board might show up at this time in this place. They won't be discussing, deliberating, or acting on official business. This notice is just being issued as a courtesy. Something along those lines. Just in the interest of transparency, so the public doesn't wonder why you're secretly meeting at certain places without telling anyone. Just something we highly recommend doing. If you're going to have one of these social events or seminars or whatever, where a quorum might show up, you have to make sure you resist the temptation, the urge to talk about official business. As soon as your quorum starts talking about official business, you're having a meeting, and if you didn't do a notice and an agenda and all that stuff, you're violating the open meeting law. So the best thing you can do is just avoid these situations. But if you have one in which you can avoid it, you have to be there all at the same time, you got to make sure you don't talk about official business. Third requirement is an agenda. You got to have an agenda. You got to tell the public what you're going to be talking about. What are you going to be doing? What are you going to be talking about? I took a look at the agenda for this meeting. That's definitely above average with how good it is. I didn't get to read every part of it, but it sure looks like it's following the requirements. And what are those? You need to list everything you're going to talk about, consider, decide, vote on. Anything that's really going to happen at the meeting needs to be listed on the agenda. And it needs to be as specific as you can be so that the public will have a reasonable understanding of what's going on. If you just list business, that's not going to be good enough. People aren't going to know what that means. You need to be specific. What business? What's happening? And everything on the agenda, that is all you can talk about. You cannot talk about things that are not listed on the agenda. I'll probably repeat that at least 3 or 4 more times today. Some common issues with agendas: writing them in a way that people can understand them. Don't use all your fun government acronyms or all your fun legal terms that your average person might not understand. If you want to use FBI or NASA, people will understand those. But if you're going to use all your super specific acronyms that really only you government folks know, then the public isn't going to understand what you're talking about. So try to avoid that, or at least define what you mean by that in the agenda. Additionally, it's fine to use those general categories: new business, old business, personnel, but then you need to explain below what is the new business, what is the old business, so on and so forth. If you just have your agenda organized with general topics like that, the Attorney General is going to come knocking and you're going to get in trouble. So you need to be very specific. There is one exception to the requirement that everything you want to talk or discuss needs to be on the agenda in detail. And that is if you're going to give a brief summary of current events. You can just write on the agenda as a particular item, brief summary of current events, and then the presiding officer or a member of the public body can get up at the front, give a very brief summary of current events, sit back down, and no more discussion on that. And you don't have to list every single current event on the agenda, just the headline current events. So if you want to get up there and say, hey everybody, thanks for making the food can drive a great success. Don't forget we have the other event coming up this week, and so on and so forth, you can do that as long as it's just a summary and then there's no further discussion. If you want to discuss those items further, make sure they're their own specific items on the agenda. If it's not on the agenda, do not talk about it. Probably one of the easiest ways to violate the open meeting law is to talk about stuff you just didn't put on the agenda. Sometimes you forget to put something on the agenda, or something big comes up that you really want to talk about. Well, if it's not on the agenda, do not talk about it. 1, it's going to be illegal. You're going to get in trouble. 2, if you take action on something that's not on the agenda, that legal action might be rendered null and void by a court, and you might be in all sorts of additional difficulties later on. If you absolutely want to talk about something, you need to get it on the agenda for another meeting with 24 hours notice, so on and so forth. Some issues that come up from time to time with meeting locations: have the meetings where people can show up and attend. Don't have your meetings in a members-only club. Don't have them in a basement that only has 3 chairs so that barely anyone can attend. Don't have them at 3 in the morning on a Monday morning. Make sure that it's a reasonable time, reasonable accommodations. If you have reason to believe 500 people are going to show up, do your best to accommodate those people. So what does the public have a right to do at a meeting? This is something that I don't think a lot of members of the public know, and I don't think a lot of members of public bodies know. The public's rights are limited to these 4 items. A member of the public can show up to a meeting, they can listen, and they can record it on either a tape recording or video recording. These are the only 4 things that the public has a right to do under the open meeting law. The open meeting law grants no other rights to the public. The public has no right to speak, no right to disrupt at a meeting under the open meeting law. It's possible that for your meeting, it might have some sort of specific additional requirements. You might have to allow the public to speak at certain meetings. If you have a special zoning meeting, your local ordinances or other statutes outside the open meeting law might require that you allow for public comment. Confer with your attorney or your legal counsel for questions about that. But generally, under the open meeting law, the public has no right to speak at a meeting. If someone continues to assert that they do have a right to speak at your meeting and they routinely disrupt, eventually you're probably going to want to remove them. What I suggest doing is every time they step out of line and make a very clear statement to the public of what is allowed and what's not allowed, and make a good record of the warnings. So if you eventually do have to remove someone, you have a record of how it went down, and you have evidence to show you did things right. So you don't have to let the public speak at your meetings. There's no right, but you can give them that right. You can allow the public to speak at your meetings. You can issue what is called an open call to the public. Again, it's optional. You do not have to do it. But once you do it, you're going to have to follow some rules and fit some criteria laid out by the law, and that's in concert with the First Amendment. So if you have an open call to the public, you can place time, manner, and place restrictions, reasonable time, place, manner restrictions on speaking. So you can tell people each only have 2 minutes. Please don't curse and shout obscenities, so on and so forth. The way the courts have looked at it and the way the Attorney General has looked at it, particularly the Attorney General has determined that you can ban repetition. So if you know 100 people are lined up to speak on one side of an issue and they're going to say more or less the same opinion, you can ask that they basically select a few people to speak on behalf of them, or just you're going to limit each side to a certain amount of people. I suggest avoiding doing that unless you really, really can't avoid it, because then you're likely to get complaints that my opinion wasn't heard, I was treated unfairly, and then you're opening yourself up to all sorts of headaches. But according to the Attorney General, you can probably limit the amount of speakers on a certain side of an issue. Yes? So if you have a call to the public, what do you need to do to do what? Just stop putting it on agendas for future meetings. So the question is, if we normally have calls to the public and we no longer want to have them, what do? Stop having them. Take them off your agenda and just don't list that you're going to do it anymore. Well, I wouldn't be surprised. Some of the folks that call our office, I'm sure, would challenge that, but they could scream and shout about it all day long, and they do not have a right to have their time to talk. You can tell them instead, here's how you can contact the members, here's their email address, their mailing address, so on and so forth. But they do not have a right at every meeting to go stand up at the front and have their 2 minutes where they shout about whatever they want to shout about. So what happens if a member of the public brings up something at a call to the public that isn't on the agenda? That's fine. The public can talk about things that are not on the agenda. You, as board members, however, still cannot. So if a member of the public, brings up something for discussion that's not on the agenda, you're limited to what you can do. You can ask your staff to study the matter, ask that it be placed on an agenda in the future. That's really it. Do not talk about it. Do not engage them on that issue unless it's on the agenda. Additionally, what you can do is if someone directly criticizes you as a member of the board, you can respond to that criticism, but you need to do it in a way in which you're not really talking about specific items that aren't on your agenda. So if they criticize how you handle a particular issue, you need to be careful about not getting into the specifics of that issue unless it's already on the agenda. And if you're going to do any of those 3 things, you need to make sure you do that at the end of the call to the public. That's the way the statute is written. I don't know how strongly that's enforced. I think a lot of public bodies will address something said in a call to the public as it's done. But the way the statute is written, you should wait until everyone's had their say at the call to the public, and then you should address whatever you want to address. That's the way I suggest doing it, and I think that's what the law requires. Below or on this slide are a few things that aren't necessarily violations of open meeting law, but which are probably going to give you big headaches and potentially get you in trouble. So if you recall, again, a meeting is a quorum of your public body that's discussing, deliberating, proposing, taking legal action. So what happens if the members are up here, the member on the right is talking, and 2 of the other members are whispering, and then they're having 3 or 4 people passing notes back and forth, something along those lines? Well, if that's about official board business, they might be violating the open meeting law, because that needs to be available for the public to hear and listen to. If you're just passing notes back and forth about what you're going to have for lunch or how great the Diamondbacks did last night, That's not technically a meeting, it's not technically a violation of open meeting law, but it's going to look bad. People don't know what you're doing up here if you're whispering or passing notes or picking up your phone every 30 seconds and laughing. So I suggest not doing that. It looks bad to the public or to many members of the public, and it opens you to complaints and criticisms that you're not going to want to deal with. So I suggest avoiding doing any sort of conduct like that up at the front. Another issue which you got to keep in mind, it's a pain and it's going to seem hard to deal with and unfair at certain times, but it's the way the law is written. A lot of members of public bodies like to talk with their constituents before and after meetings. That's fine. You can talk about issues with them all day long. However, if a quorum gathers for one of these pre or post meeting conversations, you need to be careful. If your meeting ended at 5:30 and you're all out back at 6 p.m. talking with a constituent about a particular issue that could come before your board, you're having a meeting. You have a quorum deliberating or discussing board business, and all of a sudden you're having an illegal meeting. So you need to be very cognizant of who's around and what you're talking about. So if you just want to be out back one-on-one with a constituent, you can talk about whatever you want to your heart's content. But if the whole board shows up or a majority of your board shows up, then you really shouldn't be talking about any official business. Yes, ma'am. So if you have a board and they show up 15 minutes early to a meeting and they're just hanging out up here and they're talking about nothing official, nothing that could come before the board. So again, the weather, how great the Diamondbacks are doing, your favorite food, something like that. Should you have someone in there making sure that things aren't going to go off the rails, or should you basically have a witness in there to vouch for them if someone challenges it and says, hey, what were you talking about? That's up to you. The law doesn't say anything about that. If you want to have someone in there standing in the corner politely reminding the members every time they get close to veering off the rails, that's fine. I don't know how much they will like that. Some members don't like being told what to do or reminded they might be violating the law. But in my opinion, the more safeguards you have, the better. And it shows the public that you do care about the open meeting law. But it's up to you guys. So generally, meetings are supposed to be open to the public, but as most of you know, there are exceptions. There are 7 situations or 7 circumstances in which your board can meet in private in what's known as an executive session, where you have a discussion about a certain topic and the public isn't allowed to be there. When you have one of these executive sessions, not only can you be in private, you have to be in private. So if you're going to hold an executive session, nobody from the public can be there. There's only 7 circumstances in which you can do this. I'll get into those in a little bit more detail. The executive session must be listed as an item on your agenda. So just like anything else you would talk about, you need to tell the public up front that you might do this. You need to vote publicly in order to go into executive session. So if you're going to meet secretly to talk about something, you need to have an open vote in public to tell the public what's happening. Anything that is discussed in executive session is confidential. You cannot tell anybody. That is the way the law is written. You cannot take legal action in executive session. If you want to vote on something, it needs to be done in public. You can never be voting on something in executive session. And even though it's going to be confidential, you still need to have a minutes or recording for your executive session. It should be kept separate from the minutes or recording for your open meeting, but you still need to have one for your executive session. Something to keep in mind, just because you can have an executive session doesn't mean you should. Very rarely do you have to go into executive session. If you're going to talk about confidential information, then yes, you need to go into executive session to keep it confidential. But if you're going to do just about anything else, you get to make the decision about whether you want to go into executive session. Sometimes it'll be worth it because you don't want to reveal contract negotiations or have everyone hear your legal advice you're obtaining. But other times it might not be worth the headache. People are going to complain. This is legal. The legislature wants this to be able to happen, but you're still drawing attention to the government meeting in secret. So you have to make the call on whether the secrecy is worth the headache of people being unhappy about you going into secret. So you need to balance public suspicion versus actual need and make a judgment of whether it's worth it. Your notice or your agenda must include that you might go into executive session. It needs to explain which statutory provision allows you to go into executive session. And your agenda needs to explain what you're going to be discussing in executive session. You don't need to go into as much detail as you do with regular agenda items, but you need to go into enough detail that it's more than just saying we're going to get legal advice. Well, you're going to get legal advice about what? Or you're going to discuss which personnel, something along those lines. But you don't need to put as much detail as you normally would. So who gets to show up? Well, obviously all members of the public body. Makes sense. If you're discussing personnel, if you're going to executive session to discuss whether to hire or fire someone, then that person, you can have that person attend if you'd like. The Auditor General can show up to an executive session if they're conducting an audit, and then any other individuals whose presence is reasonably necessary to carry out the purpose of the executive session. So if you're going into executive session to obtain legal advice, well, your attorney is going to be pretty necessary to be there. If you need to record the executive session or have someone write down minutes, well, then it makes sense that you're going to have a clerk attend and do that so that the members don't have to do it. You need to have a good reason for why that person is necessary to be there. And what you should do, it's not specifically required, I don't believe, by the open meeting law, but you certainly should do it in the sake of transparency, and that is to explain in your agenda or in your minutes or both who attended the executive session and why they were there. You don't need to explain why your lawyer was there or why the members were there, but if somebody else is there who at first glance might not make sense, explain why they were there. Common issues that happen with executive sessions is telling people what happened in it. It's corny, but I always make the reference to the movie Fight Club, where the first and second rules of Fight Club were don't talk about Fight Club. Same thing applies to executive session. Do not talk about executive session. Do not tell anybody what happened in it. If you do that, you're violating the law. In fact, the chair of the public body is supposed to specifically remind everybody in every executive session that it's confidential and not to talk about it. Another issue that commonly comes up is public bodies voting in executive session. Do not do that. You cannot vote in executive session. You cannot take legal action. You need to come back out into public to do that so the public can see who's voting, what you're voting on, and who votes which way. First reason you can go into executive session, I've already alluded to, is for personnel discussions. So if you have a particular employee that you want to discuss whether to hire, fire, demote, promote, so on and so forth, you can have that discussion in the executive session. However, it needs to be a specific individual. If you're just going to discuss whether to raise or lower all the salaries of your county employees or your district employees, that's not good enough. You can't have that talk in executive session. It needs to be specific individuals that you can identify. There's a special requirement if you're going to have an executive session personnel discussion. Whoever you're going to talk about, you need to give that person specific individual written notice at least 24 hours in advance telling them that you're going to talk about them in executive session. So you have your normal notice for the meeting, and then you need to give that person notice that you will discuss them in executive session. And that person can say, no, you're not. I want you, if you're going to discuss me, you're going to do it out in the open. And if they request that, then you have to do it. So if that person doesn't want you talking about them in executive session, you cannot talk about them in executive session. You can either do it in public or you can't do it at all. The open meeting law does not give the subject of a personnel discussion explicit right to be at the meeting. So I don't believe that person is entitled to be in executive session. They can instead ask for it to be out in public. But you can allow them to attend. The way the law is written, it's ambiguous, and the Attorney General is of the opinion that you can allow that person to attend the executive session hearing in which you talk about them. But it's up to you. They don't have a right to be there specifically in the open meeting law. A couple questions that come up relatively frequently. Can you do personnel evaluations in executive session? The Attorney General's opinion is yes, and I agree with it. Can you interview people for positions? Can you conduct job interviews in executive session? Again, the Attorney General thinks you can. See either one of those Attorney General opinions for more. So if you do interview someone in executive session, fine, but when you want to vote on whether to hire them, that vote has to be done in public. Second reason, again, I alluded to this, that you can go into executive session is if you want to discuss confidential information. So if you have HIPAA protected information or FERPA protected information that you need to discuss, then you can go into executive session in order to keep that confidential and not violate the law in disclosing it. Pretty obvious, this is probably the most common reason there's ever an executive session, and that's for legal advice. A public body can go into executive session to obtain legal advice from their attorney. Your discussion in the executive session has to be limited to the public body talking to the attorney and vice versa in order to obtain that advice. You cannot be in executive session to debate what to do with that advice. So once you get your legal questions answered by the attorney and they give you the advice, you're done. If you want to talk any more about what to do with it and how to proceed, you have to go back out into public. The other 4 other reasons you can go into executive session, these don't come up quite as frequently, so I won't go into detail. If you're going to direct an attorney or discuss with an attorney how to conduct litigation or contract negotiations or settlement, you can go into executive session. If you're going to negotiate with a union about salaries, you can do that. Interstate, international, tribal negotiations, executive session. And lastly, if you're going to discuss whether to buy or lease actual property, real property, you can do that discussion, that limited discussion in executive session. But again, all legal decisions have to be done in open session. The last requirement from that slide I mentioned earlier is the most important slide to remember, is minutes. You are required by law to either take written minutes or a recording of your meeting and make that available to the public within 3 days from the time of the meeting. It used to just be that it was written minutes, and now it's written minutes or a recording. Two legislative sessions ago, the legislature got very close to changing that to where you had to do both, a minutes and a recording, or just a recording, that you needed to do a recording. It came very close to passing, but it didn't quite get there. So be aware that that might change in the future because it's on the legislature's radar. But right now, it's just either a minutes or a recording. So what do your minutes and your recording have to have? Pretty common sense, straightforward stuff. You need to basically tell the public the who, what, when, where, why. Who met, when did they meet, where did they meet, and then what happened. Who was there, which of the members wasn't there, what did you discuss? You don't have to go into a lot of specifics, but you have to give someone who wasn't there a good enough idea of what was talked about that they'll understand. An accurate description of any legal actions you took. So what did you vote on and what happened? The names of whichever member proposed something, whoever made each motion. Anyone who presents to the board, their name should be in the minutes as well or on the recording. So if I was presenting today in a meeting, my name should be in the minutes that Danny Garone presented on the open meeting law, made a presentation to the board. And any legal action that someone presents related to, it should be noted that they were presenting on that topic. So if I'm presenting on a specific topic that's on the agenda, it should be noted that that's what I'm talking about. Very, very, very common question. Someone wants to see our minutes, someone wants to see our recording. Do I have to make that available to them, and how long do I have? You have 3 working days from when the meeting occurs to make your minutes or recording available. So if it's 3 days, if you had your meeting on Monday and it's now Thursday afternoon, someone calls you up and says they want to see the minutes or they want to see a recording, you need to make it available to them. You either need to let them come in and look at it or you need to provide a copy to them, whichever they want. You can't withhold it because it's not done yet. You can't withhold it because it's drafted or hasn't been accepted or approved by the board at the next meeting. You do not have a choice. You have to provide it. If it's not done, if it hasn't been approved, you can write unapproved or draft on it, but that's it. You have to make it available. Cities and towns have some extra requirements, extra fund that the legislature has given to you guys. If you have a population of 2,500 or more in your city or town, not only do you have to do the minutes and or recording requirement, you also have to post on your website within 3 working days a summary of legal actions you took at the meeting or a recording. And then once you approve those meeting minutes, you need to put those on your website. And those need to be on there for a year. This doesn't apply to counties, doesn't apply to special taxing districts, doesn't apply to state agencies, just municipalities. Why? I'm not really sure. I have a feeling that when the legislature added this new requirement. There were some issues and some complaints about cities and towns, and so the legislatures decided to show that they cared and that they were going to stick it to cities and towns over the open meeting law. Very common question comes into our office. The County Board of Supervisors doesn't have their minutes online. I can't find them anywhere. They're violating the open meeting law. That's not true. The open meeting law doesn't require that minutes be routinely posted online. They need to be made available if you want to see them, but they don't have to be actively put online like the notice or agenda is. So just something to keep in mind. If you can't find minutes for a board, you should call them up and ask them for it. Subcommittees and advisory committees in towns and cities over 2,500 also have to follow those extra requirements. They have to post a summary of legal actions taken or a recording. They just have a longer period of time to do it. You get 10 working days if you're one of those committees. So as I mentioned earlier, you do need to have minutes or recording for your executive sessions. It needs to have date, time, and place, who was there, what did you talk about. You need to have an accurate description of the instructions given so that don't talk about this, don't talk about that. Note that in the minutes. Anything else you think is necessary to put down in your minutes. These are going to be kept confidential, however. So why are we doing it? Why are we taking minutes or recording of our executive session if nobody gets to see it? Well, some people do get to see it. Members of the public body can see it at a later time if they want. Makes sense. If someone was talked about, it was a personnel discussion, that person has access to the minutes or the recording. The Auditor General, if they're conducting an audit, the county attorney, AG, or the courts, or the Ombudsman's office, if any of us are conducting an investigation, we can see those minutes. And that's it. The public doesn't get to see them. This should go without saying, but just in case it doesn't, do not try to be sneaky and get around the open meeting law on technicalities. I will go into it again later, but there's a statute, the final statute in the open meeting law basically says the whole point of the open meeting law is for openness, and anyone in charge of interpreting it should interpret it in favor of openness. The Attorney General likes to, in my opinion, use that language to come after and press public bodies on those tough in-between cases that aren't 100% certainly violations. They will press you on the idea that you're violating the spirit of the open meeting law. So you can't use any sort of technological device to be sneaky and get around it. You can't do what is known as splintering the quorum. So if we have a 7-member board, quorum is going to be 4. If we want to meet individually, I meet with one member, and then the other member tells about our conversation to 2 other members. It's reached a quorum. It's reached 4 members. So even though it didn't happen simultaneously, a quorum deliberated or discussed, and we had a meeting, and we violated the open meeting law. Don't poll the other members on how they feel on a particular issue. Don't send an email to all 7 of them saying, hey, how are you going to vote on this issue? That's the equivalent of discussing or deliberating, and you'll be violating the open meeting law. Or you'll be close enough that the Attorney General is going to come after you and make your life unpleasant for a while. Again, I noted that serial communications are going to still potentially bring you in the realm of open meeting law. So it doesn't matter if it's letters or emails. If whatever you're sending to each other gets to a quorum, you're violating the open meeting law. Doesn't need to be simultaneous. There's an Attorney General opinion on this, but you're probably not going to need to refer to it. It's pretty much the common view now. You can't, open meeting law does apply to email communications. So be careful about emailing each other on a public body. So if you have your 7 or 9 members of your public body on the board, if you're emailing each other about a whole bunch of issues, you're going to be having a meeting, and you're going to be violating the open meeting law. Again, that's for proposing, discussing, deliberating, or taking legal action. You can email all day long about how great the finale of a TV show you watched last night was. That's fine. But as soon as you start talking about anything that could come reasonably and foreseeably before the board for action, you're barking up the wrong tree. Again, electronic communications treated the same as if you were in the same room together. So don't use Facebook messages, Instagram, Snapchat, any of that stuff. Send telegrams, or if you send birthday cards with recordings that you recorded about what you're going to talk about at a meeting, all of that can be a violation. So just an example of how this works. You have a 5-member board. Your quorum is 3. If one member sends an email to 2 other members and then they respond, so all 3 are emailing each other, that's a quorum. If they're talking about board business, then they're having a meeting. And unless they did a notice, an agenda, and made it available for the public to see in real time, you're violating the open meeting law. Is there any sort of distinction? If it's fact you're sharing or opinion? No. If you're having a discussion on facts or opinions about something that can come before your board and you have a quorum, you're probably violating the open meeting law. The Attorney General has, the way they view the word deliberation in the statutes is any collective acquisition and exchange of facts preliminary to a final decision. So if you're talking about anything that could come before your board, you're having a meeting as long as there's a quorum. However, I'll get into this distinction in a little bit more detail, but the Attorney General takes the view that it needs to be a two-way communication. So if you're having a meeting, if a quorum is deliberating, discussing, proposing, or taking legal action. According to the Attorney General, deliberating and discussing need a two-way communication. So if one person emails the rest of the board, so a whole quorum of the board, their opinion on an issue, but nobody responds, everyone realizes it's a danger zone, there might not have been a violation of the open meeting law because there wasn't technically discussion or deliberation. Someone would have needed to respond in order for there to be discussion or deliberation. I recommend not testing that out and trying your best to walk that line. I would avoid emailing the whole board or a quorum. I'm sure most of your public bodies have something like this on the end of your emails. This is very common. Just a note to remind whoever might be receiving it that be careful you don't forward this around and accidentally commit an open meeting law violation. There's no problem with staff emailing the whole board or a whole city council or whatever your public body is. Just receiving information from staff generally is okay, depending on what the information is. So it's okay to send the board packet around or to send out the agenda so that everyone can see what's going to be discussed at the next meeting. That's fine. So I mentioned earlier, to violate the open meeting law, you needed a two-way communication in most situations. There's one example, and that's proposing legal action. If you propose legal action, the Attorney General's opinion is that's a one-way thing. One person is needed to propose something. So if I'm on a 5-person board and I email the other 4 people and say, I think we should take this legal action at the next meeting, I've just violated the open meeting law. I've proposed legal action amongst a quorum outside of a proper meeting. So you should never, ever be proposing legal action to a quorum of your public body outside of a meeting. Well, then how do you come up with agenda items? Well, you can propose an item to be discussed at a meeting as long as you don't propose what legal action you want to take. So it's okay to basically give the topic, but not the outcome that you want. I'll give you some examples. And I realize this might be frustrating or might seem like a pain in the you-know-what, but this is the way it is. So I send an email to all the other board members. At the next meeting, I want to discuss safety at First and Main. That's okay. I'm not proposing any legal action. All I've said is I want to discuss a general issue. That would be fine. The second example, I email everyone and say, we should install a crosswalk at First and Main. I've proposed an actual action. I want us to build something. That would be proposing a legal action. That would be illegal. You got to leave out the action term. You're just saying that you want it to be discussed generally at the next meeting. You're not saying exactly what you want to be done or what you think the board should or should not do. First one, I think we should consider firing the city manager at our next meeting. You're proposing legal action. You want the board to go into detail about whether to fire somebody. That's the action, firing. Something you would need to vote on at the meeting. Versus the second one, you just want to discuss the performance of the city manager at the next meeting. You're not proposing any action. There's no action in there except discussion. You just want to discuss the topic at the meeting. You're not saying we should fire, hire, demote. So the first one is bad, the second one is good, because you're not proposing legal action in the second one. Just a couple more issues about executive sessions. Say you have a situation where the board meets in executive session to discuss pending litigation. That's one of the 7 reasons, so that would be okay. Then the board directs their legal counsel to appeal a court decision. and then the board never votes on it. So the board has taken legal action with no vote. That would be improper. You need to vote on whatever you decide to do in open session. You can't make legal decisions in executive session. Just a couple more fact patterns. You have a board member sends an email to a quorum stating that the board should implement a program like the one described in the article they attached to the email. That would be a problem because you are suggesting you implement. You're proposing that the board take a specific action implementing a program. That's proposing legal action. That would be illegal. Now contrast that with the second example. The board member sends an article to the quorum, just a news article. Maybe it's an article about this new program that another state is piloting, and there's no comment. They're not saying it's good, and not saying it's bad, not saying they want to do it. That would probably be okay. You didn't propose any legal action. You didn't suggest that the board do anything. If someone responds to that email to the whole board and says, I think that's dumb, or I don't like it, or it's the best thing I've ever seen, all of a sudden now you're having a deliberation or discussion, and you're violating open meeting law. So be very, very careful when it comes to emailing each other around. It's so easy with how quick and easy it is to fire off emails to start talking about improper things through email. So one way to avoid email issues is to never email, if you're on a board, never email the rest of the board. Let your staff do that sort of talking, and that way nobody's replying all to you by accident and violating the open meeting law. Because once you send an email, it's out of your hands, another member might forward it to everyone, and all of a sudden the sky is falling and you don't know what to do about it. Another example, this is a little more nitpicky, a little more difficult to deal with, but again, this is the way the open meeting law is. This is the world we live in. A board member sends an article to a quorum of the board, and another board member responds with a dueling article. So if you send an editorial that says, this is why this program is the best thing there's ever been, and you should implement it, and someone else responds with another editorial that says the opposite, it's probably the equivalent of sending opinions back and forth and deliberating. So that would probably be an open meeting law violation, and the Attorney General would probably come knocking on your door. So avoid a situation like that. The second one here is a more interesting situation. You have three members exchange emails, so they're having a discussion on a topic. However, the quorum for that board is 4, so it's less than a quorum. You're not technically having a meeting. So you think you might not be violating the open meeting law. However, depending on the situation, the Attorney General might still view that negatively. If you've got one member short of a quorum, are you being sneaky and trying to get around the open meeting law and have your discussions in private? If those 3 people send emails to each other saying, hey, keep it to just the 3 of us so that we can discuss this and not be violating the open meeting law, and then no one will ever be able to see what we talked about. If your intention is to get around the open meeting law, that's going to be viewed negatively by the Attorney General and the courts. If those 3 people then show up to the meeting and then don't talk at all, don't give any opinions, and then they all vote the same exact way silently, that's going to look bad, and the Attorney General and the courts might rule against you on that because you intentionally skirted the open meeting law. Your intent was potentially to hide from public exposure, and the whole point of the open meeting law is so that the public sees what you're doing. So I suggest trying to be sneaky and avoiding the open meeting law. If you just happen to have lunch with another board member and you just discuss something that might come before the board at some point in the future, and then later it does, and you talk about it at the meeting, that's fine. That's probably not going to be a violation. But if you sit there and game it all out and then don't do anything in public later, that's going to look suspicious and you might get in trouble for that. You cannot direct your staff to violate the open meeting law. Your staff will get in trouble, you will get in trouble. And anyone who knowingly aids someone in violating the open meeting law can be sanctioned under the open meeting law. So staffers, if you ever get put in a tough situation, I apologize, but I suggest you do not help someone violate the open meeting law, even if it costs you your job, because you can become a criminal. So if your job is more valuable than that, I would suggest reevaluating. There's one random interesting exception toward the end of the open meeting law that basically allows, in limited situations, members of a public body to address the public, even though they know a quorum will hear what they have to say. I'm not sure how often this comes up. I'm not sure you will ever have to worry about it, but know that there is an exception so that you won't get in trouble if you do this. So the situation I always envision is you're leaving, the Board of Supervisors is leaving, the last member's trickling out by themselves, the others are already gone, and a local newspaper or a local TV station comes and puts a microphone in front of your face and asks you to talk about something. You know that the rest of the members are probably going to hear about it, and if you propose legal action, usually that would be a violation because you're proposing it to and a quorum is going to hear. But the legislature has specifically exempted those type of situations from the open meeting law. You're not committing a violation, as long as that wasn't your intent. If you go intentionally seek out a member of the media so that you can sneaky reach the other members outside of an open meeting, and there's proof of that, I don't know how there would be proof of that, but if there's proof that that's what you were trying to do, then you could get in trouble. But just know that this is out there. I don't know how often this will ever come up, but it's in the law, sort of enshrines your ability, your free speech rights in the open meeting law. Again, as long as you're not as long as you're not specifically addressing the other members and you don't have any sort of plan to get around the open meeting law, you can talk to the public or to the media to your heart's content. So when in doubt, I've said this multiple times, but I think it's worth repeating. Resolve all doubts in favor of openness. The legislature has specifically put in the open meeting law that you should do this. That's not that common. The legislature doesn't always tell you the reason behind the body of law you're looking at and how to interpret it. But in this case, they have. So there's no doubt that in tough situations, courts and the AG are going to err on the side of openness. So if you're like, I might not technically be a violation, but it's a tough one, resolve it in favor of openness. That's the best way to make sure you don't get in trouble. And it's just better generally for how your board will be perceived by the public. Any legal action you take during a meeting that had improper violations of open meeting law might be rendered null and void and struck down by a court. So if you pass a budget at a meeting where you violated the open meeting law, somebody sues you 3 months later, a court rules on it, that court might undo that vote you did on the budget, and all of a sudden you're in a world of difficulty. So a very, very strong incentive to make sure you comply with the open meeting law. So what do you do if you think you violated an open meeting law and you're in the middle of a meeting? You can recess it, get with your attorney and assess what's going on. If you can resolve the issue and move forward, go ahead. There's certain types of open meeting law violations that won't taint your whole meeting. Again, if you have questions in the heat of the moment, consult your attorney about it. If after a meeting at which you think you committed a violation, what do? Determine if you need to ratify it. There's a procedure in the open meeting law to where if you mess up, you can basically do a ratification process at a future meeting where you're basically reapproving whatever you did at the last meeting and making it okay. So maybe your illegal action would have been null and void, but you can ratify it at a future meeting to make it legitimate. So if you mess up, get everyone on the same page about what happened, and so it won't be repeated again. If you get a complaint, be transparent and open about it and address it. Do some training or whatever you need to do to get everybody back on the same page of following open meeting law. This is the ratification process. It's in 38-43105. If you ever get to the point where you need to do this, I suggest you stop and talk with your legal counsel so you don't make it worse. There are special steps you need to take, and if you mess those up, then all of a sudden you've basically added another layer of error and illegal activity onto an already bad mess. So within 30 days after you discovered or should have discovered the violation, you can ratify it. You need to do, instead of 24 hours notice for a ratification, you need to have 72 hours of notice, and you basically need to describe in your agenda and your minutes why you're ratifying, what went wrong. Basically, you need to come clean about what happened and what you're doing to fix it. If you violate open meeting law, what's going to happen to you? Well, if you violate open meeting law or help somebody violate it, you can get a civil penalty. You can get fined up to $500 for each violation. And your board isn't going to pay that. You're going to pay that. So steer clear of blatant violations of open meeting law. Your bank account will be better for it. Courts can take other equitable remedies against you. Like what? I don't know. I wouldn't want to be the one to find out. And you can also be on the hook for reasonable attorney's fees. If a court finds that you intended to deprive the public of information, that basically you were being sneaky on purpose and trying to shield things from the public, The courts can even remove you from office. They can throw you right out of your elected position. I don't think that happens very often, but I wouldn't want to be the one to test it and see if it will happen. I mentioned this earlier. A bill from 2 sessions ago in front of the legislature would have made it a requirement to record all meetings, but it failed. That might change in the future, so be aware. And that's about it. I have a few more scenarios, but I think I've probably walked through enough hypotheticals to put everyone to sleep. I know there's more to the meeting, so I will pause for questions. Anybody have any questions? Yes, sir. Social media is the same way. The question is, so we talked about emails and other electronic communications, but what about social media? If you send private messages back and forth on Twitter or Facebook or something like that, and it goes amongst the quorum and it talks about something that can be before the board for action, you're having a meeting. So unless the public can see that, and there was a notice and an agenda and minutes and a recording, you're violating the open meeting law. So theoretically, if you have notice, an agenda, and public availability, you could theoretically have a meeting online. If you had like a Facebook chat group that any member of the public could see in real time, and you had 24 hours notice and an agenda, theoretically you could have a legitimate meeting that way, but I would caution you against that if possible. One, it's not going to be perceived well by a huge chunk of the population who's not tech savvy or wants to see it in person. Two, so much can go wrong with it that I would suggest avoiding that. But generally, it does not matter how you're communicating. If you're communicating amongst the quorum of your board about anything that can come before your board for activity, for official action, then you're having a meeting and you need to be following the open meeting law. It does not matter what the format is that you're communicating in. Yes, ma'am. Yes. Are you talking about like an internet chat? Okay. You got to be very careful. It could easily spiral out of control. If your answer was just a factual answer, someone asked, well, what time is the building open? And you respond, that's going to be fine even if the board sees it. But if someone says, how do you guys feel about the new bill the legislature is passing or the budget shortfall we have? And you respond so that all the other members can see it, and then another member chimes in, oh geez. Now you're having a discussion. Unless you had notice, agenda, and all the other good stuff, you're violating the open meeting law. So you need to be very careful about that. Your face appears very frustrated.
Before you said that they still can come, but if you actually have the question, you don't come on.
Well, there are situations where the public's just not doing, some people are not going to like it one way, some aren't going to like it the other way. What I suggest doing would be saying, hey, why don't you send that to me in an email, and I'll answer it for you. I do not want to violate the open meeting law by discussing this in public where the other members might chime in or see my opinions. People are still not going to like that potentially, and that's just, unfortunately, that's the cross you're going to have to bear as a public official. There are going to be times where you have to make a hard decision regarding the open meeting law, and people might not like it. Unfortunately, that's just the way it is. You can't make everyone happy with these things. Does that answer your question?
Yes. So let's say I have a person that put a statement on my and that's other
So the question is, if I'm a public official, I'm a member of a public body, and I just post a statement, I imagine with some sort of opinion in it, on Facebook, on your official government Facebook or whatever, on your personal one, so that everyone can see it, is there a problem? If you propose legal action, there might be a problem if a quorum sees it. If you don't, if you're just giving your opinion on something and other people see it, as long as they don't chime in, a quorum doesn't chime in, then you don't have a problem. It's an interesting situation because not only do you have the open meeting law on one hand, but you have the First Amendment on the other. You have a First Amendment right to say your opinions in public. So I don't think the Attorney General is going to come after you for giving opinions to the public on your Facebook. If you're doing it in a way that it's super obvious you're trying to have a discussion with the other members, then you might run into trouble, but that would be a hard thing to prove. But if you just like to give a monthly update on how you feel on the issues to your constituents, I think you're probably entitled to do that. One, under the First Amendment, and two, under that exception that I mentioned about addressing the media. I think the courts would probably extend that exception to online postings, as long as you're not trying to get around the open meeting law. Well, one way to do things would be to not allow other members of the public body to comment on your online postings. Make your Facebook posts off limits to comments from other public officials. And if you're a public official, don't comment on other board members' posts. You're just barking up the wrong tree. That's going to lead you right off the rails and into trouble. Is there another question? Any other questions? Yes, sir. Yes. So what are the penalties for violating the open meeting law? Generally, it's up to $500 per violation, and any other equitable remedy the courts think is necessary. I don't know how often they make another penalty, and you could be on the hook for attorney's fees. If your violation was basically an intentional violation where you were trying to keep things secret from the public and deprive the public of information, then you can also be thrown out of office by a court. So if you intentionally violated the open meeting law in a way that you tried to deprive the public of information, that's when you can get ejected or removed from office. I don't know of that happening. I'm sure it has. But the open meeting law is not supposed to be a gotcha game. It's not the legislature trying to get people in trouble. It can be difficult, but if you're trying your best and you're doing things, you're going to make mistakes. You're eventually going to make some sort of mistake. Admit the mistake, move on, do whatever you need to do, take your lumps, and that'll probably be it. You're very rarely going to be fined. You're almost never going to be thrown out of office. Really, the only time those are going to happen is if you're repeatedly violating the open meeting law and you're just showing disregard for it. You don't care. That's probably the only situation where you're really going to suffer monetary or official penalties. Otherwise, at most, what the Attorney General usually does is they want your board to sign something that, yeah, we messed up and we fixed it and we'll get some training and not do it again. That's usually how it goes. But if you then proceed to ignore what you've learned and do it over and over and over again, that's when you might finally get in more serious trouble. Any other questions? Yes, ma'am. You should be, the clerk of the board should be able to make it available to you, or you can call our office or email me and I'll send it to you, whatever you'd like. Yes. Okay. So you're asking whether the county says where your board's meetings can be found? I don't personally know what Mojave County is doing. Just off the top of my head, I can't remember exactly what the requirement is for special districts. But if I were you, I would get on the same page as the county on that. And if the county's not doing it, then you need to do it. Someone needs to be doing it. If neither your board nor the county are posting where your notices can be found, then there's a problem. So I would suggest go and call up the county and say, hey, are you doing this for us or not? We need to get to the bottom of this. But I don't personally know what Mojave County is currently doing for the fire districts. So unless there's any other questions, that's going to wrap it up for the open meeting law, and thank you very much for having me and bearing me out here.